disclosure on that. As I say, good afternoon, everyone, and welcome to today's session. I am Sean Gibb, the Events and Marketing Manager at Pro Manchester, and I'm delighted to welcome you to today's webinar, which is What's My IP? Conducting a review of your trademark and design protection during lockdown, and it's hosted by HGF. Today's speakers are Lauren Summers, Chartered UK and EU Trademark and Design Attorney, and Lee Curtis, Chartered Trademark Attorney, both from HGF. Following today's session, I'll send out a post-event email, which will contain any post-event collateral, links to where you can find out about other Pro Manchester events, and our new Pro Manchester YouTube channel, where you can view some of our past webinars you may have missed, and you can take a second look at today's session. Please hit the subscribe button while you're in there, and then you can stay up to date with all the latest content. This post-event email will also contain our feedback form, so if you could please fill this in, it really is helpful to continue for us to improve our offerings and provide consistently great content. Just for one more time, just to make you all aware, this webinar is being recorded. Please keep your microphones on mute. You may want to switch your camera off as well. And please use the chat function to ask any questions, comments, observations, and we'll try our best to answer some of those towards the end of the session. So without further ado, I'll hand you over to Lauren.
Thank you, Sean. If you don't mind, I'll just share my presentation. I won't be a moment. There we go. Can you see that, Lee?
I can see it, yes, Lauren.
Good. So welcome everybody, and thanks for joining our webinar today. It's intended really for startup businesses, smaller businesses, or businesses that have dabbled in IP a little bit, but are wanting to get a bit better understanding about how they can protect themselves. And we thought that lockdown was a good time to do that. I know lockdown has eased a little bit now, but you know, it's a good time to take stock still. So where to start when you're trying to conduct a review of your IP? Well, first of all, you need to know what IP is, so what you're looking for. And trademarks are the, I guess, the core of mine and Lee's work, and they indicate trade origin, so where anything comes from. I've popped up an example there of Google. Apparently Google's the biggest trademark in the world. So it can be anything that signifies your business, be that a word, an icon, a combination of stylization and words. It might be a house brand. It could also be a product name. So Apple would have Apple as the house brand and iPhone as the product name. So basically anything that signifies where your product or service comes from. Then with designs, that focuses on the look. So it will focus on the look of a product or part of a product. And it can also apply to services such as a website or an app. Uber have design registrations for the look of its app when the user goes on to the very first page. So that's what you're looking for, really. Those are the two key types of IP that we're going to talk about today. There are two other types of IP. You've got patents. They are protection of anything to do with technical inventions, and you've got copyright. Copyright exists automatically, so there's no registration process. There isn't much to do with copyright, so we've not covered that today, but it's just so that we've at least acknowledged its existence at the start. So when conducting a review, I like to think of it as a bit of a stock take approach, and essentially the first thing to do is look at what you've got. What are you putting out there on the market? what's on display for consumers. So I've got a picture there of a store. What are you trying to market and sell to consumers, basically, be that a product or a service? And what names have you used for those products or services? How do they look? Do they look quite different to things that have been on the market before? There might be something in that, be that a design registration or design right. And then have a look at what you've got secured in the stock room under this kind of stock take approach. Have you got everything that is on display on the shop floor backed up in the stock room? That's kind of the assessment that we're trying to make in this mini audit or review of anyone's IP, if we ever do this for clients, or if you're trying to conduct this type of review yourself.
So with regards, well, I'm Lee Curtis, and I obviously work for HGF, but with regards to trademark rights, when you're taking stock, as Lauren said, you need to consider that trademark rights can be established in two ways. The first is, at least in the UK and other common law countries of the world, and to describe the common law countries is basically the UK and anywhere that speaks English or was basically part of the British Empire. You can establish trademark rights simply via using a brand. Now, use as such doesn't, it's via building up goodwill. So when we talk about goodwill, it's what they call the attractive force that brings in custom, but it effectively means you've used the brand, people know of you, and they come to you because they know of your brand, and that can be protected via the common law tort of passing off. So when you're doing Lauren's stock take of IP, you shouldn't only consider registered trademark rights, you should also consider what brands, what logos, what looks have I used in the past, because you could have established common law goodwill under those terms, and therefore that's part of your stock of IP. The other major way where you can build up trademark rights is via trademark registrations. So we've given an example there of a trademark registration for HGF. You can register it at the UK Intellectual Property Office in the UK, but also you can register it country by country. But there's also transnational trademark systems such as the European trademark or the Madrid Protocol. So you can actually register things, and it's almost, I would term a trademark registration is like a house deed. So it's exactly the same as a normal property right. So what your trademark registration would delineate is what is the trademark. So there we've got HGF. What is the scope of the trademark? So what goods and services you've registered it for, and you'll see there we've registered it for legal services, and also from when it dates. So when you're doing your stock take, you need to remember that you've also got rights via use and you've got rights via registration. So next slide, Lauren. But you also need to think about how brands develop and how your business is traded over the years. One of the most important things is that trademarks change. We've given an example at the top of the Apple logo, and you can see how that look or design of the Apple logo has changed over history. So the first Apple logo was almost very figurative. I think it would be hard to actually find the apple in that logo, but it's then developed over time to a very quite rainbow zany 1970s logo, to quite an 80s, 90s, quite a basic logo, and then you've got the silver logo at the end. Now, what you need to remember is you may have registered or bought a business with a trademark registration that may have been registered 20, 30, 40 years ago. We've got some clients who've got trademark registrations over 100 years old. But you need to remember that these trademarks change, and you may not have registered it in the form that it was originally registered, and you're now using it in a different form. And this can be important in defending things against non-use attack. So if you have, in most countries of the world, if you don't use your trademark for 5 years, it can be attacked on the basis of non-use. And it's important that you're trying to use the trademark that you've registered as clearly as possible. So going back to Lauren's stock take of your IP, you need to look back to say, am I using the same trademark that I was 20 years ago? Does my registration accord to that? Another thing where things may change is that your business may develop. We've given another, with regards to products and services. So we've given another example there of Apple. Apple obviously started off in the computer hardware sector, but over time that's morphed. So they've moved into mobile phones, they've moved into Apple Watches, they've moved into more laptops, they've moved into iTunes. So effectively their business has grown and morphed over time. So again, looking back at Lauren's example of the stock take, you may have a trademark registration which covered a certain area of business. 20 years moves on, you may actually not be in that business at all, and now, and you're not using it in relation to the goods that you originally registered it for, so it can become attacked again under non-use. So when you're doing your stock take and looking at what trademark rights you've got, you need to remember these things, that trademarks change and that your business may develop. Another important thing to consider is the trademark registered in the right company name. This is quite important because it's possible through history the company may have been struck off. You may have dissolved the company, the rights may have remained in an old company name. You just need to keep things up to date. There may also be changes. It may have changed from a trading company, or you may have it in a holding company name, or you may have it in an IP holding company name, but you just need to keep up to date that you have basically the right trademark registered for the right goods and services and the right company name, because if you need to enforce it against anyone, all those three things need to be correct. So next slide, Lauren. So there are potential also for cost savings when you're doing your stock take, because if you think about the shop example, the whole point of the stock take is to get rid of unwanted goods or sell them off cheap to make some money out of this unwanted stock in the back of your shop. So if you have your trademark portfolio, both registered and unregistered, is there ever any overlaps of protection? So have trademarks been registered over time which have basically built up on each other, because you could allow certain rights to lapse. You have to pay a renewal fee every 10 years in most countries. So you can look back at your trademark portfolio and say, do I have too much protection? Because I may be simply paying out money to renew this registration just automatically when I could allow it to lapse. Also, as we said, I've got that on renewal. So renewals are often overlooked in when you're managing a trademark portfolio. You need to be proactive because you can save money. Also, we've got there is seniority claims. I talked about transnational rights. If you have a European trademark registration, which covers the whole of the European Union, there is a possibility, if you've historically got trademark registrations in all the countries of the EU, national rights, so say you may have registered it in Poland or in Germany or in France, and then you've got a European Union trademark registration over the top of that, you can make seniority claims, which basically enable you to claim the national right date in relation to the EU registration, and you can allow the national registration to lapse. And again, you can save money on renewals, and this is another form of overlap. Also, if you have a trademark which might be of interest to a licensee in your stock room, you may not have an interest in using it directly anymore. But say you're a clothing brand, you may want to license that to other traders to make a license fee. You don't necessarily have to trade yourself. You can use the licensee's use to maintain your registration. Also, again, when we're talking about the stockroom, is there a sell opportunity for your trademark registration? Because it's possible you may have a trademark you're no longer interested in, but somebody else might be interested in. So you could sell that. So I think Lauren's analogy to a stockroom or a shop is quite crucial, that you look at all this. Do you have old stock? Do you have unused trademarks that you can sell and move on? So now, Lauren.
Yeah, thanks, Lee. So now that you've had a look at what you've got, the next question is, what are you missing? So to identify the gaps in protection, because hopefully you've saved a bit of money by either selling some marks or not doing a couple of renewals if there's some overlaps in protection, so you can then focus your resources on protecting the stuff that's missing. And it sounds really basic, but it's just having a look at what you've got on display that isn't, like we said, backed up in the stockroom. Trawl through your website, your app, your marketing materials, your product range, and see if you've given something a particular name that isn't registered but is attractive to consumers. Is that something that's worth protecting? Most of the time the answer is yes, to some extent. So that might be a sub-brand or a product name. It might be an add-on service that you provide, that you market specifically to a section of your consumers. And then icons, you might have an app icon that consumers identify you by. Obviously the Instagram and the Facebook ones are the ones that you see everywhere at the bottom of every single website. People see those, and obviously they've come to represent the two social media platforms. So these are all crucial elements of intellectual property that you could protect. And I'll go through how you might go about doing that in a moment, but it's making a list of those areas where you think you have gaps. At the end of that slide, I've mentioned non-traditional trademarks, and those are even things like shapes, sounds, even store layouts have been attempted to be protected. So to give you some examples, Kit Kat famously attempted to register the shape of the 4-finger chocolate bar, and they had a lot of pushback on that, both from trademark offices and competitors, not wanting them to be able to monopolise that shape. So there's difficulties in registering shapes that I won't go into in any more detail, but it's an option. Sounds, things like the MGM lion roar that appears at the beginning of many movies, that is trademarked. And Apple have registered in a few territories the store layout, because you know when you're walking into an Apple store without even having to look at the sign above you, because it's set out in such a distinctive way. So anything that's distinctive and you think signifies your business might be something that's worth protecting. So how do you take a commercial approach? Because it could be, how long is a piece of string? You could say, Lauren, I've made a list of 30 potential trademarks that I could register, but I haven't got the money to do all of that. So the key is to prioritize. Begin by identifying what are your core trademarks and look to protect those first, and then take a filtered down approach. So if I just hop over to my next slide, I can show you, this is how I would do it in my head. That's how I break it down. So it's an upside down pyramid, and this is in terms of where you spend your IP budget. Your core house marks, look to protect those as far as possible in all of the territories that you trade in. Then second to that, you might have your secondary sub-brands that you protect, the key ones in the key territories where you trade. Tertiary marks, those might be an even further product name, or an add-on service to your service offering. So you could consider some registered protection for those. Say if you're operating in the UK the majority of the time, and the EU, you might just look to protect it in the UK. And then transient marks were, they might be around for a short amount of time. So those might be catchy slogans or icons that you're using to promote a summer range or a winter offering. Those might be marks that you don't spend any money on. You might choose to just rely on unregistered rights for those. So you don't have to register everything that moves, basically. It's not always a good idea, and you can overkill, but that might be how you prioritise your budget. And just skipping back, there's ways of filing for trademark protection in a cost-saving way. So Lee mentioned the EU trademark system that allows you to file a single application and secure protection in 28 member states, or soon to be 27 when we officially, or when the transition period ends at the end of the year. But there's also what's known as the Madrid Protocol International Registration System, and that allows you to file an application in your home territory and then file a single application designating a number of territories within one application, within one further application. So Australia, China, US, Canada is a recent member. So not all countries are a party to this system, but when it's available, it is a really good cost-saving way of filing for protection in a lot of territories at once. Because essentially, you don't need to use foreign lawyers unless your application encounters difficulties. So you're saving on foreign attorney fees, basically. And then things like the priority period, which I've mentioned there, it doesn't necessarily save money, but it can allow you to spread costs. So the principle of priority means that you can file in a first territory and then wait 6 months and file in foreign countries, but claim back the earlier filing date. Sorry, I don't know why my slides are skipping there. But you can claim back the earlier filing date of your first application. So there's not that mad rush to get everything filed at the start. You can spread the costs a little. So moving on to other trademark related things that you might want to secure if you've come up with a strategy for securing protection for some of your brands in terms of registered trademarks. It's also important to try and secure any related domain names and social media handles. Now, it's not always possible because the internet and Instagram and Facebook are a crowded market already if you were coming up with new brands. But it should be, I guess, at the forefront of your mind when selecting a new brand. Can I market this through social media? Can I get the related website? Because there are squatters in operation also. So if you file an application, we've had a couple of instances with clients, haven't we, Lee, where they've filed an application and haven't necessarily secured the domain name, so the website handle, straight away. And within a couple of hours or a day or two of then trying to do that after filing the trademark application, they found that somebody's got in there before them. So unfortunately, there are some not so nice people monitoring the register, seeing what people are filing, and then registering the corresponding domain name or social media handle. And then it's tricky to try and get it back. So there are mechanisms that you can retrieve domain names that are filed in bad faith. So if you could show that, this person will have spotted that your trademark was lodged at the UK Intellectual Property Office, on X date, and then the day after they registered it, and they have usually they have a pattern of this type of behaviour. You can sometimes get it back, but then in other instances you can't. So put an example of this lady, Chanel, on the slide, and she is a young woman in Canada, and she obviously acted very quickly when Instagram first ever existed, I guess, and registered the @Chanel domain social media handle for her personal account. Chanel, the fashion brand, have tried to get this off her numerous times, but it being her name, she isn't actually doing anything wrong unless she starts putting misleading content on there to say that she's affiliated with official Chanel or is the official fashion house Chanel. She's entitled to do that. So it's about getting your ducks in a row before launching, and sometimes even before filing any trademark applications in terms of domain name and social media handles. Just to say, Facebook and Instagram also have takedown reporting systems, but they'll only enforce registered rights. They don't take kindly to unregistered trademark right claims. They're not lawyers, they're not courts. Well, they may have some lawyers on the books at Facebook and Instagram, obviously, but they don't want to make a decision on whether somebody has unregistered trademark rights, which often requires a lot of evidence being submitted and considered. So they like to receive a certificate saying that you have a trademark, usually for a word mark. They prefer word mark registrations, so they don't then have to do any further in-depth assessment as to whether you have rights and whether you can assert those rights. So then once you've got everything secured, what do you do with it? And it's essentially about enforcing the rights you've worked so hard to identify and then secure. Using them properly is the first and foremost important thing to do. So use them as a trademark. You can put an R in a circle symbol next to the mark when it appears on any marketing materials, online, on your social media handles, to show people that it is registered. And I've put an image of jacuzzi on there because jacuzzi is a registered trademark, and they have to enforce it quite strictly, really, because every bubble bath that sits in your garden isn't a jacuzzi. It's a whirlpool bath, or every bubble bath that I guess sits in your bathroom isn't a jacuzzi just because it has the jet bubbles. There are other brands of whirlpool baths, so they have to try and avoid it becoming generic. So avoid people referring to every bubbly bath as a jacuzzi. And the way to do that is say the brand name followed by the descriptive terms. So, this is a jacuzzi whirlpool bath. It's not just a jacuzzi. And another example might be, this is a Ford motor car. It's not just a Ford. I mean, obviously Ford is a well-known brand and there's less risk of that becoming generic, but it's the way you use the trademark that enforces in the mind of consumers that it's a brand and avoids this slippery slope down to genericism that others have, failed at. There's the example of escalator is used quite a lot when we try and explain this to clients. So escalator was a registered trademark, but it became known as the only name for a moving staircase. So essentially that right was lost in the end. And then another way of effectively policing your brand is to, as well as keeping it safe and secure from a distinctiveness perspective, keep it safe and secure from other parties to avoid any consumer confusion or blurring so dilution of your rights in a sense. And you can do that by putting in place a trademark watching service. But these are pretty cheap to put in place, and they cost about £500–600 usually for a worldwide trademark watching service. And that will notify you of any trademarks being filed anywhere in the world that are identical or similar to your brand in relation to identical or similar products. And if you then perceive a conflict and you have rights in that territory where it's been filed, you can file an opposition to prevent that mark from being registered and being in conflict with yours on the register. And if somebody's filed an application, it's also a signifier that they are likely to use that brand in that market, so you can take action against that use also if necessary, and of course if you have the rights to do so there. You can also put in place domain name watching services, so it will notify you of any domain names that are registered or updated that are identical or similar to your brand. Again, you can just check through the content. They might have just been purchased and parked. There might not be any content on there to do anything about, but they also could be used to sell counterfeits, as a phishing site. We've had instances with clients where scammers have registered domain names that are similar to clients' brands, and then use the corresponding email addresses to contact potential suppliers and get money out of them, basically. Place orders, get money, and then the products never arrive. So the domain name watching service is helpful to some businesses. And then monitoring social media platforms and e-commerce sites, because there are the takedown notices that I mentioned earlier. There are monitoring services available for these types of platforms and sites as well. Less commonly used by smaller businesses because they tend to just keep an eye on them themselves, but there are overarching watching systems that are available for these too.
Okay, so I'll talk about designs, and I'll first deal with unregistered design rights. In a similar fashion to trademarks, where you can establish trademark rights, you can have trademark rights in an unregistered form. You can also have design rights in unregistered form. And to go back to Lauren's description of designs, that's protecting the look. So in the United Kingdom, the shape and configuration of your product, if providing that it's original, it's got an original design, can be protected via unregistered design rights. So this is a right which you don't need to register, you just obtain it via disclosure to the public. And in the United Kingdom, that's the shape and configuration of a product. It's from 10 years from first marketing in the UK. Now, UK unregistered design rights are only available to nationals of the UK or a limited number of qualifying countries, so Hong Kong and some other former colonies. But that's a form of unregistered design protection that you might have in some of your products that you need to be aware of. There's actually also a wider EU unregistered design right that not only protects shape and configuration, it's actually wider. So it protects lines, contours, colors, surface decoration of the article. Now that lasts less than the UK unregistered design right, which, as I said, lasts 10 years. The EU unregistered design right only lasts 3 years from first marketing. EU unregistered design right was really designed for the fashion industry, for fast-moving products, which basically come and go with seasons. That's why there's only 3 years protection, but it is wider. So, for example, if you're a clothing firm or if you've got any designs which particular the importance or the distinctiveness is in the color or surface decoration or motif, then that's something that you you may well have. Now, I'm not going to go into Brexit. This isn't a talk about Brexit, but the basic rules with regards EU protection for the UK is, come the end of the transition period on the 31st of December, you should have exactly the same rights that you had before the 31st of December. So the government is introducing new unregistered design rights in the UK to fill a perceived hole between UK and the EU. So I think I'm not going to, there's very complicated things about Brexit, but basically what I would say is don't worry. Your protection will be maintained on the unregistered side. So as we've said there, look at your product range. Is there any innovative, any original looking product from a design perspective that you may well then have unregistered design right in that product? Also, Lauren's touched on this before with regards retailing or store layouts. You can, in theory, register those as designs. Also, don't get too obsessed that this is all about product, the look. You may have a feature of a website. So Facebook, for example, is registered the format of the Facebook page. And also it's an unregistered right potentially. Also, if you have a mobile app, the look of that mobile app could potentially have unregistered designs or registered designs. So next slide, Lauren. So this just gives some example of the things that you can register or can get design rights in. So like I said, it could be a textile article. It could be a very industrial article. I think that's a safe. Could be more of a fashion item. It could be more of an industrial or a more functional product. So, for example, there we've got a hose. So if that has a distinctive look, then there's a potential that you have design rights in it. And also even packaging. So, for example, we've got the Lockix example there. So that's in sort of design speak, a combination of colors and lines. So that would have unregistered design right protection. So next slide, Lauren. So when the one misconception regarding, and this also touches on copyright as well, it's exactly the same rules. If a design is created by an outside agency, there's a potential that the commissioner, well, sorry, the person outside owns it. So what we would always advise, and this also covers copyright, because copyright can protect an artistic work and they overlap with designs, is just make sure that you have an agreement where all the IP rights are signed into you as the owner. So even if you've given money out, you need to be aware that particularly with regards copyright, that the author is the owner, and that author, if they're not in your employ, they own the copyright rights to it. We've gone on there. If there's an employee who've created this and it's in their normal course of their normal employment, then the design rights are owned by the employer. And again, that applies to copyright as well. But if someone created something outside of their employment, so for example, I don't know, J.K. Rowling, this applies to copyright. She obviously was employed in another job. She went back and wrote Harry Potter. Her employer doesn't own those rights. It's owned by her because she didn't do that in her normal course of employment. And if you're an employer, you probably should have clauses in your employment contracts regarding intellectual property that it reverts to you, to be clear. And this goes back to keeping good records of creation and ownership. Unregistered design rights and copyright are by definition unregistered. I think you can, in theory, get it on some centralized database with regards to copyright, but you don't need to do that, and most people don't do that. But what you need to do, because it's an unregistered right, both unregistered design rights and unregistered copyright, is if you ever have to go to court or ever to enforce it, you need to prove when it was created, who it was created by, so keep good records. Now, there's the myth that you can stick things in the post and send it back to you. You don't need to do that. All you need to do is keep good records. So if it's on computers, just make sure it's saved, dates are saved, so you can prove who created it, when and where. So next slide. Also, there's overlapping rights, obviously, with unregistered rights, but they can potentially protect a part of a product or the whole product. And when you're thinking about registration, you need to think about what is particularly distinctive about this design and concentrate on that. So you can file multiple design applications registering parts of the whole. Also, you have 1 year to register your design from first marketing. That's at least in the United Kingdom and the EU. So if you've got a product and you want to go off and register, you can wait a year and you can see how that product goes and how successful it goes. And then you can file a design application to register it. That's what they call the 1 year grace period on disclosure. However, if that 1 year grace period is gone, and you haven't gone off and registered it, that registration would be invalid if you ever did register it. So you just need to bear in mind when you're thinking about design registrations just bear in mind that 1 year period from first disclosure, because once that's gone, you cannot get registered design protection. Now, registered design protection in the UK and the EU lasts up to a maximum of 25 years. And it can be renewed every 5 years in that 25 years. So you can effectively monopolize the look of a product or the look of a website for 25 years to give you a monopoly right. Now, just to give you a horror story about disclosure and the 1 year grace period, we've got a picture there of the Crocs shoes. I have no idea why Crocs became a fashion item, but it did. But it was originally launched as a shoe for boats in Florida, in a Florida boat show. So the Crocs shoe was designed for basically sailors, recreational sailors, to have this shoe on a boat. It was never designed as a fashion item. They launched this at a specialist boat show in Florida. Then subsequently, the Crocs shoe took off massively as a fashion item. Millions and millions of these shoes were sold, but they delayed filing their EU design registration for 2 years after that initial disclosure at the Florida Boat Show. They got a registration because things go through without a full examination on designs. But when they went off to try and enforce it against third parties, the third parties brought up the fact that they disclosed it 2 years before at a Florida boat show. Now, they argued, well, no one knew of that disclosure in Florida. It was a yacht show. No one in the EU knew about it. But the judge said with the internet and with global PR, the fact that it's on the internet is disclosure worldwide. Crocs lost their main design registration for that shoe by basically self-disclosure. They destroyed their own registration by leaving it more than a year to register it. So this is the golden rule with designs. Just remember that you need to register or file your design application within a year of disclosure. So
thanks, Lee. So now Lee's talked a bit about what designs are and unregistered designs and registered designs. Hopefully you've been able to then assess what you've got and maybe what you're missing. So if you identify things that you're missing in terms of design protection, the next question is it worth registering? So I've made a bit of a checklist here, and first one is about novelty. So does it look different to other products that are out now or have been around previously? Because if the answer is yes and yes, you have then something novel that is potentially worth registering. Next question being, has it been received well by customers in the last year? So utilising this 1 year grace period, has it been a good seller? If it hasn't, and you're thinking that you're probably going to drop it within the next 12 months, then again, it might not be worth registering. It would be something that you would perhaps rely on unregistered design rights for if you needed to, if copied by a third party. But if it's been a massive seller and, you know, it's potentially going to be copied by others, then again, yes, consider registration. Because design registration is quite cheap, really. few £100 to get something registered in the UK. So it can often be better to have than not to have, if you think that other people might see your design and be keen to try and replicate it. So if you've said, okay, yes, I want to register, you again then need to think about prioritising. If you had, say, a number of designs that you could potentially register, think about which are the biggest sellers and which ones are most likely to be copied by third parties. But then preparing the design application, it's quite simple. You don't need to give away too much detail. You just need the details of who's going to own it. You can give the designer details in the UK and the EU. Usually give an identification of the type of product that it is. So whether it be a hairbrush or a handbag, or as the example on the slide there, a suitcase. But the images are vital. It all boils down to what the images look like. Your protection is defined by the set of images that you submit in any design application. And not a horror story. Another horror story after Elise Croc's tale is the Trunky saga that went on for quite some time, involving registered design rights. So Trunky had a design registration for the grayscale CAD drawing that you can see there on the slide. Their actual product is set out beside it, and then the product of the competitor, Kiddie Case, is on the end there. And Trunky alleged that Kiddie Case's ride-along suitcases infringed the registered design because they produced a similar overall impression in terms of their look. And it went back and forth through the appeals courts, and eventually it was decided that it didn't infringe because it produced a different overall impression than Trunky's registered design. Now you can see that Trunky's design has blacked out wheels and a blacked out strap, and that was quite key in the end, because that contrast was considered to be a feature of the design registration, so limited Trunky's design rights somewhat. If they had perhaps had a plain line drawing of just the outline of the ride-along suitcase, they might have had a much better case against Kiddie Case. Because what you're doing when you're assessing infringement is you're not looking at the product on the market versus the product on the market. You're looking at the design registration versus the product on the market. So getting the images correct at the start is key in terms of enforcement going forward. And if you get a registration through, like Lee said, there isn't much of an examination process, so they're pretty easy. Once you've got your drawings right, they go through within about a month's time. They're easy to get through, not like trademarks where you have a potential period for objections from third parties. The dispute with designs usually comes to the fore when you seek to enforce them. But good thing to do is to mark any products made to the design, or if it's the layout of an app, put that right at the bottom of the scroll down screen, that it's registered. So UK registered design number XYZ, EU registered design number 123, so that it signifies to others that this is a registered design and you are serious about protecting it, and that you're also serious about enforcing it. So step off my grass, basically, and keep an eye on others. So not just those in your market. It can be that the product has a different application and still infringes your rights. Now, I've put these little spiky balls here, and I think the original design registration, they were intended to be for your washing machine. So they would help with the washing and the cleaning of your clothes in the wash. But then the spiky ball was then adapted for, I think it's been used as a dog chew toy. And then also I've seen them in massage parlours or in the physio, where they try and put them on your pressure points. So the product, even though it has different applications, still looks the same. And that's what you focused on with designs. You focused on the look. You're not limited to only enforcing it against people using that look for the same purpose. It can cross markets, I guess. If it produces a similar overall impression on consumers, there could well be infringement. But it's just something to bear in mind. And then that is all I was going to say. If you have any questions, I've seen one pop up in the meeting chat. Lee and I would be happy to take them. I can address the one from Charles. Hi Charles, how are you? Charles has asked about the TM symbol.
Thanks, Lauren.
You're welcome, Charles. So Charles has asked about the TM symbol. Where does that fit in? Because I mentioned the R in a circle. And yes, you're right, Charles. It can be used against trademarks that aren't yet registered, or that you may never want to register, but you just want to rely on unregistered trademark rights, but signify to others that it is your brand, and again be another step off the grass sign. So yeah, you can use the TM symbol as well.
Although legally it has no significance. So I think Lauren's right that you use it to sort of delineate common law rights, but in contrast to the R in the circle, which basically is a criminal offence to use that when it's not registered, the TM is nice to use, but it's not crucial. Would you agree, Lauren?
Yeah, it can help, like I said, with putting off in third parties. And then if you're trying to, we haven't talked about this in today's session, but with some brands, you can try to acquire distinctiveness over time. So it might be a brand that is quite descriptive at the outset, but through mass marketing, it eventually becomes distinctive and able to indicate the origin of the products and services. You could pop a TM symbol beside that during that time where you're trying to acquire distinctiveness. And I think the Trademark Office, when examining the evidence that you submit to show that you've acquired this distinctiveness, would look favourably on instances where you've used the TM. Does anybody else have any questions? If not, I'll hand back to Sean to close off the session.
Oh, one in there from Sarah. What's the usual charge for trademarking?
So the cost depends on the territory, and also depends on the number of products and services that you wish to cover in a trademark application. But if you're just looking at the UK and one category of products, to file the application is about £500, and then to take it through to grant is usually about another £300. So to take it through all of the registration process, or the application process through to registration, so about 800 all in all.
That's if you use us. In theory, you can do it yourself. But yeah, if you use us or a trademark attorney, or that's how the costs.
So if there's no further questions, all that leaves for me to say is obviously a massive thank you to Lauren and to Lee. And thank you to HGF for hosting the event. And thank you to all of you for attending and taking the time out of your afternoon to attend. So thank you and goodbye, everyone, and I'll see you at the next one.
Thank you
Bye.
very much. Bye.
Thank you.